Okay, last but not least, we have our trademark lecture. And this one is the last one of actually our cycle of preparation for the exam. And so, as for the other, we will see the trademark law in perspective in US, China, and European Union. So let's go forward and let's see. So the first thing is, what is a trademark? So a trademark is considered as a sign that identifies and distinguishes in the marketplace the products of one enterprise from those from the other. The trademark is different from a brand, as the first is a legal concept, while the second is a broader marketing concept. Trademarks serve as powerful tools for communication. They encapsulate the intellectual and emotional attributes of a company, its reputation, and its products and services. Trademarks are not limited to words and can be universally recognized design, like the Nike swoosh. In a crowded marketplace, trademark then help customer easily identify a specific business, its reputation, and products, influencing their purchasing decision and reducing the likelihood of seeking alternatives. Trademarks are often used by customers as search keywords on the internet and social media, driving traffic and improving the brand recognition online. The value of trademark can increase over time with the growing reputation of the business. They can be extended to different industries, sold, licensed, or used as security for loans. Basically, trademarks become the face of the business itself, its reputation, its recognizable feature, its recognizable face in the market itself. While we have seen that patents are its innovation, and instead copyright is the expression of the individual idea, or the idea of the person building that particular company. Trademarks could be then compared to patent and copyright. Trademarks protect words, phrases, design, or combination that identify and distinguish goods or services, indicating their source, prevents others from registering a similar trademark for related goods or services, and helps in stopping unauthorized use of the trademark itself. While patents are for technical invention like new chemical composition, mechanical processes, or unique machine design, which are new, unique, and industrially applicable. Protects the inventor's rights by preventing others from copying, making, using it, or selling the invention without permission. Copyright instead covers artistic, literary, or intellectual creation like novel, music, movies, software code, photographs, and paintings. These works must be original and exist in a tangible medium. Grants exclusive right to reproduce, distribute, perform, or display the work, and prevents others from copying or exploiting the creation without copyright holders' permission. So basically, you will have a pyramid here in which patents are on top of the IP world, as they protect the cutting edge technology. The requirements are higher to achieve. Their value when they are sold is actually higher, and is even based on the fact that they protect something unique in a technical field that could be actually used for business and could actually have an economic return. Is not an expression, but is the idea itself, basically, that here is going to be protected. So an invention itself, innovativity itself. While copyright, that is in the lower threshold, has a lower threshold in terms of what is protected. It doesn't need to be novel, it doesn't need to be industrially applicable, it doesn't need to be useful, industrially applicable, useful, or unique. But instead, it just needs to be original, intended as a minimum spark of creativity, and connected to the author. So therefore, copyright is a lower threshold to be obtained. It is not registered as they are the patents or the trademarks, and as it is automatically given, this means that it's more difficult to prove, for example, in court or during the infringement, while patents are basically way simpler because basically you will have a document attesting when you have registered that patent. Trademarks instead protect the face, the logos, the marketing part of a brand, of a company, and hence its public figure, its public face. As patent, they will need to be registered, and this means that they have a higher value in comparison to copyright due to the fact that they are registered, that they could increase in value during time, and so on. And because free sale doctrine and all the shenanigans about the distribution are not used in trademarks or patents. This means that while copyright holder, once he sold the ownership, could not have as a free sale ban basically on any other achievement, and the same in distribution, right? For patents and trademark instead, these limits does not apply. So you would have a stronger IP right that goes beyond the limits that are seen in copyright, and besides that, that protects two different things. Patents, as we say, protects innovation, innovativity of a technical field, while trademarks protect the face of a company itself and its reputability in the market. Let's go to the history. I'll do it a little bit faster, this one, because we have a lot to talk about. So trademark history is started actually in the ancient world, as we have the first utilization of trademarks since the Roman Empire. In 1876, we have the bus trademark, which is the first trademark to be registered in UK and maybe in the world. That is a red triangle. In 1883, the Paris Convention, which is an international agreement that began to establish the principle of protecting IP, including trademarks. In 1891, we'll have the Madrid Agreement, which is an international treaty to facilitate trademark registration in multiple jurisdictions, that is still applicable now. In 1994, the TRIPS Agreement, that is part of the Marrakesh Agreement, establishing the WTO and sets some minimum standards for many IPRs, one of which is trademarks too. Let's go to the theory of trademark. The purpose of trademark is to represent the brand of a company's good or services and act as a shorthand for the goodwill associated with them. They can be the same as the company name, like Coca-Cola, but not always, like Bookings Holdings, which owns trademark like Kayak and OpenTable. Trademark rights can last indefinitely as long as the trademark is used in commerce and maintenance fees for registered marks are paid. Trademark owners have the power to prevent others from using or registering similar marks for similar goods or services based on the potential for consumer confusion. There are four main types of trademarks, which are trademark, service mark, collective marks, and certification marks. Trademarks is any sign that individualizes the goods of a given enterprise and distinguishes them from the goods of its competitors. Service marks instead are signs that enable the consumer to distinguish between the different services, insurance companies, car rentals, etc. Collective marks instead are marks that is owned by an association which itself does not use it, but whose member may use it if they comply with the collective mark regulations. And at the end, certification marks are marks that could be used by anyone who complies with precise standards. So it has an open shop principle instead of the closed club principle as in collective marks. So what does it mean? That trademarks, as we say, are signs that individualize the goods, okay, of a given enterprise. Service marks instead are related to services. Collective marks are then owned by an association that wouldn't use it, but whose member can use it if they comply with the collective mark ideas and regulations. Certification marks instead could be used by anyone who complies with particular standards, for example, DOP marks and so on, that claim about the quality of the product or claim about the original identification of the product. Under Article 15.1 of TRIPS, a trademark is any sign or any combination of sign, capital capable of distinguishing the goods or services of one undertaking from those of other undertakings, and shall be capable of constituting a trademark. Such signs, in particular words including personal names, letter, numerals, figurative elements, and combination of colors, as well as any combination of such signs, shall be eligible for registration as trademark. Where signs are not inherently capable of distinguishing the relevant goods or services, members may make registrability depend on distinctiveness acquired through use. Members may require, as a condition of registration, that sign be visually perceptible. Article 15 of TRIPS hence includes word, personal names, letters, numerals, figurative elements, combination of colors, any combination of the previous. The article requires three main principles that are visual perceptibility. The trademark should be capable of being represented visually. Distinctiveness, the sign must be capable of identifying the goods or services between the others, and no unjustified encumbrances. The nature of the goods or services shall not be an obstacle to the trademark. Now let's see in US, EU, and China. In US law, under 15 US Code Section 1127 or Section 45 of the Lanham Act of the 1946, the term trademark includes any word, name, symbol, or device, or any combination thereof, used by a person or which a person has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter to identify and distinguish his or her good, including a unique product, from those manufactured or sold by others, and to indicate the source of the goods even if that source is unknown. Section 9 of restatement of third and fair competition. A trademark is instead a word, name, symbol, device, or other designation, or a combination of such designation that is a distinctive of a person's goods or services, and that is used in a manner that identifies those goods or services and distinguishes them from the goods or services of others. A service mark is a trademark that is used in connection with services. Then, what can be protected as a trademark under US law? As always, as Section 45 of Lanham Act, the term service mark means any word, name, symbol, or device, or any combination thereof, used by a person or which a person has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter to identify and distinguish the service of one person, including a unique service from the service of others, and to indicate the source of the service, even if that source is unknown. Titles, characters, name, and other distinctive features of radio or television programs may be registered as service mark, notwithstanding that they or the programs may advertise the good of the sponsor. Again, under Section 45 Lanham Act, we have the definition of certification mark, means any word, name, symbol, or device, or any combination thereof, used by a person other than its owner, or which its owner has a bona fide intention to permit a person other than the owner to use in commerce, and files an application to register on the principal register established by this chapter to certify regional or other origin, material, mode of manufacture, quality, accuracy, or other characteristic of such person's goods or services or that the work or labor on the goods services was performed by members of a union or other organization. Section 11 of Restatement of Third and Fair Competition instead define a certification mark as a word, name, symbol, device, or other designation or combination of such designation that is distinctive of goods or services certified by a person, but produced and marketed by others, and that is used by others in a manner that certifies regional origin, composition, quality, method of manufacture, or other characteristics of the goods or services. Again, in section 45 Lanham Act, we have the definition of collective mark as a trademark or service mark used by members of a cooperative, an association, or other collective group or organization, or which such cooperative, association, or other collective group or organization has a bona fide intention to use in commerce and applies to register on the principal register established by this chapter, and includes marks indicating membership in a union, an association, or other organization. Section 10 of the Restatement of Tiered and Fair Competition, definition of collective mark. A collective mark is a word, name, symbol, a device, or the designation or combination of such a designation that is distinctive of a cooperative, association, organization, or other collective group, and that is used by members of the collective group in a manner that identifies the goods or services of member and distinguishes them from the goods or services of non-member, or indicates membership in the collective group. So, under the US law, trademarks are valid only within the states where they are used or registered. They can be acquired automatically through the use of a trademark in business operation. State registration is not mandatory but offers additional benefits and varies by states. These registrations are sometimes referred as DBAs, doing business as. These one are the state trademark, while the federal trademark, which are the kings of course, are considered more robust. Federal trademarks are valid throughout the entirety of the United States. They do not require state registration and confer extensive rights, including nationwide use and the ability to seek injunction, monetary damages, and to prohibit importation. Federal trademarks adhere to the Madrid Protocol, allowing for international protection. Let's see the notable cases on what could be protected and what could not. We have the first case, that is Qualitex Co. versus Jacobson Products Co. in 1995, in which the Supreme Court ruled that color alone can indeed be registered as a trademark, provided it acquires distinctiveness and serves as a source identifier. Boss Corp versus QSC Audio Products in 2022, in which the Federal Circuit clarified that the owner of a certification mark cannot control the nature and the quality of goods and services in the same way a trademark owner can. The mark certifies that the products meet certain standards, but the mark owner does not control or produce the goods or services. BMC Software Inc. versus Computer Associates International in 2022, the court considers factors like the similarity of the marks, the similarity of the services, and the channels of trade and advertising. Let's go to EU law. Under Article 4 of the EU Trademark Regulation, EU TMR, a new trademark may consist of any signs, in particular words including personal names or designs, letters, numerals, colors, the shape of goods or of the packaging of goods, or sound, provided that such signs are capable of distinguishing the goods or services of one undertaking from those of other undertakings, and being represented on the register of European Union trademarks, the register, in a manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded to its proprietor. Notable cases in EU are case C104/18, Red Bull versus EUIPO, the CJEU, held that the Court of Justice of the European Union held that for a color combination to be registered as a trademark, it must be systematically arranged in a predetermined and uniform way. In case C673/15P, Nestlé versus Mondelez KitKat shape, the Court of Justice decided that for a shape to be registered, the shape itself, without any marks, logos, or other graphic addition, must be recognized by the relevant public as identified goods from a particular company. What can be protected as a trademark, again, in Chinese law, in Article 8 of Chinese Trademark Law, any size, including word, graphs, letters, numbers, three-dimensional symbol, color, combination, sounds, or any combination thereof that are capable of distinguishing the goods of a natural person, legal person, or other organization from those of others may be applied for registration as a trademark. Now, let's see the criteria of protectability. The requirements a sign must fulfill in order to serve as a trademark are reasonably standard throughout the jurisdiction. Two different kind of requirements. One is the basic function, so distinguish the products or services, so the distinctiveness, while the other is not having an harmful effect, therefore misleading character or violate public order or morality. In relation to distinctiveness, a trademark to function must be distinctive. The test of whether a trademark is distinctive is bound to depend on the understanding of the consumer, or at least the person to whom the sign is addressed. The distinctiveness of a sign is not an absolute and unchangeable factor, and there are different degrees of distinctiveness, and the question is how distinctive a sign must be to be registrable. If a sign is not distinguishable, hence if you are in front of a lack of distinctiveness, it cannot function as a trademark and its registration should be refused. The main criteria for which a lack of distinctiveness is assessed are two generic terms when it defines a category or type to which the goods belong. Nobody should monopolize such generic term. Descriptive sign, those that serve in trade to designate the kind, quality, intended purpose, value, place of origin, time of production, or any other characteristics of the goods for which the sign is intended to be used or is being used. If a sign is not distinguishable, it cannot function as a trademark and its registration should be refused. The main criteria for which a lack of distinctiveness is assessed then are letters, numerals, and basic geometrical shapes. These signs are often regarded as being indistinctive and therefore unregistrable, and names and surname, company names and trade names are registrable except where they are deceptive and not distinctive. Common surnames are not registrable in some countries, for example. There is then the exclusion on other grounds we have seen. So distinctiveness is the main important feature, but of course there could be even other. And these two are deceptiveness and reference to a geographical origin. For example, trademarks that are likely to deceive the public as to the nature, quality, or any other characteristics of the goods or their geographical origin do not qualify for the registration. Reference to geographical origin, signs that are descriptive or indicative of geographical origin, are false for products that do not come from the region described or indicated. Other grounds could be partial deceptiveness, depending on the list of goods. An application may be distinctive for some, descriptive for others, and or deceptive for all others. And then, contrary to morality or public policy, trademark laws generally deny registration to signs that are contrary to the morality or public policy. And then the reservation for the use by the state, public institution, or international organization. A country generally protects its national flag, its official name, and the names of the official institution in its interest. Now let's see the various requirements in the various jurisdictions. So distinctiveness requirement in the US. Under the Lanham Act, the distinctiveness requirements serve as a benchmark for evaluating the registrability and protection level of a trademark. Distinctive trademarks are easier to defend in legal disputes and more likely to be registered without any complication. The spectrum of distinctiveness from generic to fanciful guides the evaluation. In the US, then, there is a first-to-use approach. The first entity to use a mark in commerce has the trademark rights. So the Lanham Act recognizes a spectrum of distinctiveness, which is typically divided into the following categories: fanciful or coined marks. These are the marks that are invented for the sole purpose of functioning as a trademark and have no other meaning, for example, Kodak. Arbitrary marks. These are existing words that have no logical relationship to the products or services they represent, for example, Apple for computers. Suggestive marks, which instead are marks that suggest characteristics or qualities of the goods that service, but require some imagination to make the connection, Netflix for a streaming service. Descriptive marks, these directly describe a characteristic or quality of the product or service, cold and creamy for ice cream. Descriptive marks are not inherently distinctive and are only protectable if they have acquired secondary meaning. Generic terms, these are common names for products or services and can never be trademarked. These are bicycle, for example, and so on. There is then the secondary meaning, meaning the acquired distinctiveness. I will explain even later in the presentation this one. Descriptive marks can be registered under the Lanham Act if they have acquired distinctiveness. This means that through extensive and continued case, the mark has become recognized by consumer as a source identifier for the goods or services. Evidence to establish secondary meaning might include consumer surveys, length and network of use, advertising expenditures, and media recognition. So the distinctiveness is decided in Section 2 of the Lanham Act, Section 1 or 5215 USC. This section lays out the grounds for refusal of trademark registration. It specifies that marks that are merely descriptive, deceptive, functional, or likely to cause confusion with an already registered mark may be refused registration. This section implicitly addresses the concept of distinctiveness by indicating that descriptive marks may not be registrable unless they have acquired secondary meaning. In Section 2, letter F, is a provision that allows for the registration of marks that have beyond distinctiveness for the application's good or service in commerce. It recognizes the concept of acquired distinctiveness or secondary meaning, as we mentioned before, where a mark that may not inherently be distinctive can become protectable through extensive and exclusive use. Section 43A of the Lanham Act then explain that any person on or in connection with any goods or services or any container for goods uses in commerce any words, term, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false misleading representation of fact which is likely to cause confusion or to cause mistake or to deceive us to the affiliation, connection, or association of such person with another person, or as to the origin of sponsorship or approval of his or her goods, services, or commercial activities by another person, or in commercial advertising or promotion misrepresent the nature, characteristic, qualities, or geographic origin of his or her or another person, goods, services, or commercial activities, shall be liable in a civil action by any person who believes that he or she is likely to be damaged by such act. There is a disparagement clause in the Lanham Act, which could be quoted as 15 USC section 1052. No trademark by which the good of the applicant may be distinguished from the goods of others shall be refused registration on the principal registered account of its nature unless it consists or comprises immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with person, living or dead, institution, beliefs, or national symbol, or bring them into contempt or dispute, or a geographical indication which, when used on or in connection with wines or spirits, identifies a place other than the origin of the goods, and is first used on or in connection with wines or spirits by the applicant on or after 1 year after the date to which the WTO agreement, as defined in section blah blah blah, enters into force with respect to the United States. Or B, consist or compromise the flag or coat of arms or the insignia of the United States, or of any state or municipality, or of any foreign nation, or any simulation thereof. Or C, consists of comprises name, portrait, or signature identifying a particular living individual except by his written consent, or the name, signature, or portrait of a deceased President of the United States during the life of his widow, if any, except by the written consent of the widow. Letter D, instead, consists of or comprises a mark which resembles a mark registered in the Patent and Trademark Office, or a mark or trade name previously used in the United States by another and not abandoned as to be likely when used or in connection with the goods of the applicant to cause confusion or to cause mistake or to deceive, provided that if the director determines that confusion, mistake, or deception is not likely to result from the continued use by more than one person of the same or similar marks under condition limitation as to the mode or place of use of the marks or the goods on or in connection with which such marks are used, concurrent registration may be used to such person when they have become entitled to use such marks as a result of their concurrent lawful use in commerce prior to the earliest of the filing dates of the application pending or any registration issued under this chapter. Use prior to the filing date of any pending application or registration shall not be required when the owner of such application or registration consent to the grant of concurrent registration to the applicant. Concurrent registration may also be issued by the director when a court of competent jurisdiction has finally determined that more than one person is entitled to use the same or similar marks in commerce. In issuing concurrent registration, the director shall prescribe condition limitation as to the mode or place of use of the mark or the goods on or in connection with which such mark is registered to the respective person. Okay, then always the disparagement clause explains that there is unlawful a mark that consists of a mark which, when used or in connection with the goods of the applicant, is merely descriptive or descriptively misdescriptive of them. When used or in connection with the goods of the applicant is primarily geographically descriptive of them, except as indication of regional origin may be registrable under section 1054 of this title. When used on or in connection with the goods of the applicants is primarily geographically descriptively misdescriptive of them, is primarily merely a surname or comprises any matter that as a whole is functional. Nothing in this chapter shall prevent the registration of a mark used by the applicant which has become distinctive of the applicant goods in commerce. The director may accept as prima facie evidence that the mark has become distinctive as used on or in connection with the applicant's good in commerce, proof of substantially exclusive and continuous use thereof as a mark by the applicant in commerce for the 5 years before the date in which the claim of distinctiveness is made. Nothing in this section shall prevent the registration of a mark which, when used or in connection with the goods of the applicant, is primarily geographically deceptively misdescriptive of them, and which became distinctive of the applicant goods in commerce before December 8, 1993. Last part of the disparagement clause of the Lanham Act, that is section 45 of the Lanham Act. A mark which will be likely cause dilution by blurring or dilution by tarnishment under section 1125 of this title may be refused registration only pursuant to a proceeding brought under section 1063 of this title. A registration for a mark which would be likely to cause dilution by blurring or dilution by tarnishment under section 1125 of this title may be cancelled pursuant to a proceeding brought under either section 1064 of this title or section 1092 of this title. What are notable cases in this regard? I just go in the other room, so I'll have a little bit more of light because you cannot see me at all. So let's continue. Okay, notable cases on the ground of distinctiveness. The first one is Matal versus Tam, in which the case focused on the disparagement clause of the Lanham Act, which prohibits trademark, as we say, that could be considered immoral, scandalous, or disparaging. The USPTO initially refused the Lens trademark applicants based on this clause. The case left open the question of whether the prohibition against scandalous mark in the same section of the Lanham Act was also unconstitutional. This was addressed in the case in Re Brunetti, where the Federal Circuit held that the government could not bar trademarks on the ground of being immoral or scandalous, as it would violate free speech rights. So this one is a requirement that actually fell down due to in Re Brunetti. Wandering Dago and Destito in 2018. This case instead involved a dispute over the use of a potentially offensive trademark by a food truck business. The New York State Office of General Services, OGS, denied Wandering Dago's application to participate as a vendor in an annual lunch program at the Empire State Plaza in Albany, New York, citing the potentially offensive nature of the business name. The Second Circuit Court of Appeals found that the denial of Wandering Dago's application by OGS was based solely on viewpoint discrimination, which is impermissible under the First Amendment. The court ruled that the government action, in this case, violated Wandering Dago's First Amendment rights. This ruling was significant. This ruling was significant has highlighted the tension between government regulation and the free speech in the context of trademark. Another case is Pro Football versus Black Horse in 2018. The petitioners sought to cancel a federal trademark registration of the Washington Redskins under Lanham Act, which at the time prohibited trademarks that could be seen as disparaging. The Fourth Circuit vacated and remanded the early district court judgment in light of the Supreme Court's decision in Mattel versus Tam, which found that the disparagement clause of the Lanham Act violated the First Amendment. This ruling effectively allowed the Washington Redskins to retain their federal trademark registration as the legal basis for the challenge was undermined by the Mattel decision, you see. And now, Re Brunetti, Iancu versus Brunetti in 2019. Eric Brunetti, an artist and entrepreneur, sought to register the trademark FACT for his clothing brand. The United States Patent Trademark Office, USPTO, refused to register the trademark. The federal circuits then held that the prohibition against registering immoral or scandalous trademark was unconstitutional restriction on free speech. The court reasoned that the government does not have the right to silence speech just because it finds its expression to be offensive. On June 24, 2018, in Iancu versus Brunetti, the Supreme Court agreed on the ban on immoral or scandalous trademark violated the First Amendment. Now let's see the distinctiveness requirement in the EU. In the European Union, the criterion of distinctiveness for trademarks is a fundamental aspect of trademark law, as outlined in the EU Trademark Directive and interpreted by the European Union Intellectual Property Office, the EUIPO, and European courts. Is a detailed explanation. In the EU, a trademark must be distinctive to be registrable. Distinctiveness means the ability of a mark to identify the goods or services originating from a particular business and to distinguish those goods or services from other. The types of distinctiveness in the EU law are the inherent distinctiveness. Some marks are distinctive by their very nature. This can include arbitrary or fanciful marks which have no logical connection to the goods or service they represent, or acquired distinctiveness, secondary meaning, as in the US. Marks that are not inherently distinctive may acquire distinctiveness through use. If a significant portion of the relevant public recognizes a mark as identifying the goods or services of a particular company, it may be registered. The spectrum of distinctiveness, similar to the one in the US, is fanciful marks that are made up or invented words, arbitrary marks that are common words used in an unrelated context, suggestive marks that indirectly suggest characteristics of the goods or services, descriptive marks that directly describe the goods or services. These are not inherently registrable unless they acquire secondary meaning, and generic marks, which instead are terms that are the common name of the goods and services, and these cannot be registered. The secondary meaning in the EU marks that are initially descriptive or non-descriptive, they directly describe the goods or services or common attributes thereof, are not eligible for trademark registration. However, if these marks have been used extensively and have come to be recognized by the relevant public as identifiers of the source of the goods or the service, they can acquire distinctiveness. To establish secondary meaning, the trademark applicant must demonstrate that through extensive and continuous use, the mark has become distinctive of the applicant's goods or services in the minds of the relevant consumer public. This can be evidenced by marketing efforts, sales figures, market service, duration use, geographical extent, and consumer recognition. Let's see the Article 4 of the trademark regulation. A new trademark may consist of any sign, particular words, including personal name or design, letters, numeral, colors, the shape of goods or packaging goods or sound, provided that such design are capable of distinguishing the goods or services of one undertaking from those of another undertakings, and being represented on the register of the European Union trademarks, the register in the manner which enables the competent authorities and the public to determine the clear and precise subject matter of the protection afforded to its proprietor. Article 7 of the Trademark Regulation describes what should not be registered. These are signs which do not conform to the requirements of Article 4, trademarks that are devoid of any distinctive character, trademarks which consist exclusively of sign or indication which might serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, or the time of production of the goods or of rendering the service, or other characteristics of the goods or service. Trademarks which consist exclusively of sign or indications which have become customary in the current language or in the bona fide established practices of the trade. Sign which consist exclusively of the shape or another characteristics which result from the nature of the goods themselves, the shape or another characteristics of good which is necessary to obtain a technical result, the shape or another characteristic which gives substantial value to the goods. Other could not be considered as registrable trademarks are trademarks which are contrary to the public policy or be accepted principle of morality, trademarks which are of such nature as to deceive the public, for instance, as to the nature, quality, or geographical origin of the goods or services, trademarks which include badges, emblem, escutcheons other than those covered by Article 6 ter of the Paris Convention and which are of particular public interest unless the consent of the competent authority to the registration has been given, trademarks which are excluded from registration pursuant to union legislation or national law or international agreement to which the union or the member states concerned is party, providing for protection of designation of origin and geographical indication, and finally trademarks which are excluded from registration pursuant to the union legislation or international agreement to which the union is party, providing for protection of traditional terms for wine. Article 8, Subclause 1 of the trademark relation. Upon opposition by the proprietor of an earlier trademark, the trademark applied for shall not be registered if it is identical with the earlier trademark and the goods or services for which the registration is applied for are identical with the goods or services which the earlier trademark is protected, or if, because of its identity with or similarity to the earlier trademark and identity or similarity of the goods or services covered by the trademarks, there exists a likelihood of confusion on the part of the public in the territory in which the earlier trademark is protected. The likelihood of confusion includes the likelihood of association with the earlier trademark. Now, let's see the distinctiveness requirement in China. The Trademark Law of the People's Republic of China outlines the requirements of trademarks, including the criterion of distinctiveness. According to Article 8 of the Chinese Trademark Law, a trademark must be distinctive, meaning it should be capable of distinguishing the goods or services of one business from those of others. Distinctiveness in Chinese law. The distinctiveness requirement is mentioned in Article 7 of the Chinese Trademark Law. Any word, device, or their combination that is used as a trademark shall be so distinctive as to be distinguishable. Where a registered trademark is used, it shall carry the indication of registered trademark or a sign indicating that it is registered. Limits and prohibitions are mentioned in Article 8 of Chinese Trademark Law. In trademarks, the following words, device shall not be used. 1. Those identical or similar to the state name, national flag, national emblem, military flag, or decoration of the People's Republic of China. Those identical or similar to the state name, national flag, national emblems, or military flags of foreign countries. Those identical with or similar to the flags, emblems, names of international intergovernmental organization. Those identical with or similar to the symbols or name of the Red Cross or the Red Crescent, those relating to generic names or designs of the goods in respect of which the trademark is used, those having direct reference to the quality, main raw materials, function, use, weight, quantity, or other features of the goods in respect of which the trademark is used, those having the nature of discrimination against any nationality, those having the nature of exaggeration and fraud in advertising goods, and those detrimental to socialist moral custom or having other unhealthy influences. The geographical name as the administrative divisions at or above the country levels and the foreign geographical names well known to the public shall not be used as trademarks, but such geographical names as have otherwise meaning shall be exclusive. Where a trademark using any of the above mentioned geographical names has been approved and registered, it shall continue to be valid. An acquired distinctiveness trademarks in China refers an acquired distinctiveness trades in the trademark world refers to a mark that initially may not be inherently distinctive, but gains distinctiveness through extensive use and recognition in commerce. This distinctiveness is a key criterion for registering a trademark, especially for marks that are not immediately eligible for registration due to their descriptive nature. Descriptive marks are normally the one connected with the acquired distinctiveness. Marks that merely describe the goods or services, like pizza for pizza restaurant, are or are geographically descriptive fall under this category. They are not inherently distinctive. A descriptive mark can achieve registration, as we say even before in the presentation, after being used in commerce for over 5 years, gaining recognition as associated with particular set of goods or services. This is termed as acquiring distinctiveness or secondary meaning. To prove acquired distinctiveness to the Intellectual Property Office, applicant may submit actual evidence of the mark distinctiveness, evidence of continuous market use for 5 years as proof of distinctiveness, prior registration of the same mark on principal register for similar good or services. Okay, in US, this is defined on section 2F. If you remember, we have even spoke about it before, but I read it anyway. Is a section 2F in the Laham Act, which except as expressly excluded in subsection A, B, C, D, E, and D5 of this section, nothing in this chapter shall prevent the registration of a mark used by the applicant which has become distinctive of the applicant goods in commerce. The director may accept as prima facie evidence that the mark has become distinctive as used on or in connection with the applicant's good in commerce, proof of substantially exclusive and continuous use thereof as a mark by the applicant in commerce for the 5 years before the date on which the claim of distinctiveness is made. Nothing in this section shall prevent the registration of a mark which, when used on or in connection with the goods of the applicant, is primarily geographically deceptively misdescriptive of them, and which became distinctive of the applicant's good in commerce before December 8, 1993. A mark which would be likely to cause dilution by blurring or dilution by tarnishment under 1125 section C of this title may be refused registration only pursuant to proceeding brought under section 1063 of this title. Okay. How do you prove acquired distinctiveness in the US? To prove a mark as acquired distinctiveness, an applicant must provide evidence to the United States Patent and Trademark Office. This evidence can include actual evidence of the mark distinctiveness in the marketplace, evidence of continuous and exclusive use of the mark in commerce or for at least 5 years, prior registration of the same mark on the principal register for related goods or services can also support a claim of acquired distinctiveness. Registration of the supplementary register, marks that are descriptive and have not yet acquired distinctiveness may be registered on the supplementary register, a secondary register for trademarks. While this does not provide all the benefits of the principal register, it offers some protections and can be a step towards achieving full registration once acquired distinctiveness is established, especially when we're talking about the time term for that. In the EU, instead, the concept is defined in Article 7, 1 and 3 of the European Trademark Regulation. The following shall not be registered, as we say, any trademark that is devoid of any distinctive character, trademarks which consist exclusively of sign or indication which may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, or the time of production of the goods and of rendering services and of the characteristics of the goods or services, trademark which consist exclusively of signs and indication which have become customary in the current language or in the bona fide and established process of trade. And the paragraph 1, B, C, and D shall not apply if the trademark has become distinctive in relation to the goods or services for which the registration is requested as a consequence of the use which has been made for it. In the EU, this provision applies to descriptive marks that have gained recognition among the relevant public as identifiers of the goods or services of a particular company due to their extensive use in the market. To prove acquired distinctiveness in the EU, the trademark applicant must provide evidence that the European Union Intellectual Property Office showing that the mark has become a distinctive sign as a result of its use. The evidence can include marketing data, consumer surveys, evidence of market share, duration of use, geographical extent, and how the relevant public perceives the mark. Let's see instead China. In China, the concept of acquired distinctiveness, also known as secondary meaning, is recognized in trademark law. This concept applies to trademarks that are not inherently distinctive, but have become distinctive through their use in time. The regulation governing these are part of the trademark law of the people of the Republic of China. And Article 11 of the Trademark Law, no one of the following signs may register as trademark. One, where the trademark bears only generic name, design model, or model number of the goods concerned. Second, where it only directly indicates the quality, principle, or material, function, use, weight, quantity, or other features of the goods, and signs that otherwise lack any distinctive character. Any mark mentioned in the preceding paragraph may be registered as a trademark if it has acquired distinctive features through use and is readily distinguishable. Similar to other jurisdictions, a mark in China can become registrable as a trademark if it has gained distinctiveness in the minds of a consumer through extensive and continued use. This is particularly relevant for marks that are descriptive or indicative of the goods or services. Evidence of acquired distinctiveness. To prove acquired distinctiveness in China, applicants generally need to prove evidence of long-term use, widespread recognition, market reputation, and any other material showing that the relevant public recognizes the mark as a source identifier. Now let's see the protection of trademark rights. A trademark can be protected based on their use or registration. Both approaches have developed historically, but today trademark protection systems generally combine both elements. The Paris Convention places contracting countries under the obligation to provide for a trademark register. Use does still play an important role, however. First of all, in countries that have traditionally based trademark protection on use, the registration of a trademark merely confirms the trademark right that has been acquired by the use. The first user has a priority in a trademark dispute, not the one instead who first registered the trademark. Trademark protection is not an end in itself, even though trademark laws generally do not require use as a condition for the application for the trademark registration or even the actual registration. The ultimate reason for trademark protection is the function of distinguishing the goods on which the trademark is sued from others. At the same time, trademark owners need a period after registration before the use obligation comes into effect. This is especially true of the many companies that are active in international trade. The grace period granted in trademark laws, the grace period is granted in trademark laws of the different jurisdictions, and we're going to see them. The principal consequence of unjustified non-use is that the registration is open to cancellation at the request of a person with a legitimate interest. The burden of proof should be on the trademark owner, not only in cancellation proceeding, but also in any other proceeding where the owner is alleged to have taken advantage of his unused trademark, opposition procedure, infringement, action. Non-use does not always lead to invalidation of the trademark right. Non-use can be justified in the case of force majeure and any other circumstance that is not due to fault or negligence on the part of the proprietor of the mark, such as import restriction or special legal requirements within the country. So let's see the requirement of non-use in the US law. In the United States, trademark law does address the issue of non-use of a registered trademark and the implication thereof. The relevant legislation is, of course, the Lanham Act. In the US, unlike some other jurisdictions, there is generally a requirement for use of the trademark in commerce before registration. An applicant can file an intent to use ITU, but ultimately the mark must be used in commerce to secure the registration. Once registered, the owner of a US trademark has a grace period before the use requirement is enforced. This period is important for companies, especially those involved in international trade, allowing them to commence or expand the use of the mark in commerce. The law recognizes exception to the use requirement. Non-use can be justified under the circumstances like force majeure, import restriction, or other legal obstacles that are beyond the control of the trademark owner. This means that non-use does not automatically lead to invalidation if the owner can justify it. Section 14.3, 15 U.S.C. Section 10643 provides for the cancellation of a trademark registration if the mark has not been used in commerce for a continuous period of at least 3 years and there is no intent to resume use. This is known as a cancellation due to abandonment. At any time, if the registered mark becomes the generic name of the goods or services or a portion thereof for which it is registered or is functional or has been abandoned or its registration was obtained fraudulently or contrary to the provision of section 1054 of this title or subsection A, B, or C of section 1052 of this title for registration under this chapter, or contrary to similar prohibitory provision of such prior acts for registration under such acts, or if the registered mark is being used by or with the permission of the registrant so as to misrepresent the source of the goods or a service on or in connection with which the mark is used. If the registered mark becomes the generic name for less than all of the goods or services for which it is registered, a petition to cancel the registration for only those goods or services may be filed. A registered mark shall not be deemed to be generic name of goods or services solely because such mark is also used as a name of or to identify a unique product or service. The primary significance of the registered mark to the relevant public rather than purchase motivation shall be the test for determining whether the registered mark has become the generic name of goods or services on or in connection with which it has been used. The relevant legislation instead in the European Union is the Trademark Regulation. The 5-year period after registration provides a grace period in which the trademark owner should commence the use of the mark. This is particularly important for business planning to expand for new businesses establishing their presence in the market. The burden of proof in proceeding for revocation or in other legal disputes where use is questioned is on the trademark owner to demonstrate the use of the mark or to provide a legitimate reason for its non-use. There is a justified non-use in the EU Trademark Regulation that recognizes certain circumstances that can justify non-use of a trademark. This includes force majeure or other obstacles outside the control of the trademark owner, such as legal restriction or regulatory issues. Article 18 of the European Trademark Regulation is the article that specifies that the proprietor of a new trademark must put the mark to genuine use in the Union within 5 years of registration for the goods or services for which it is registered. Failure to do so can lead to trademark being revoked. If within a period of 5 years following the registration the proprietor has not put the EU trademark to genuine use in the Union in connection with the goods or services in respect of which it is registered, or if such use has been suspended during an uninterrupted period of 5 years, the EU trademark shall be subject to the sanction provided in this regulation. Unless there are proper reasons for non-use. The following shall also constitute use within the meaning of the first subparagraph: use of the EU trademark in a form differing in elements which do not alter the distinctive character of the mark in the form in which it was registered, regardless of whether or not the trademark in the form as used is also registered in the name of the proprietor. Or affixing of the EU trademark to goods or to the packaging thereof in the Union solely for export purposes. Use of the EU trademark with the consent of the proprietor shall be deemed to constitute use by the proprietor. Revocation for non-use. As per Article 58 of the European Trademark Regulation, a trademark can be revoked if it has not been put to genuine use in the EU in connection with the goods or services for which it is registered for a continuous period of 5 years and there are no proper reasons for non-use. The rights of the proprietor of the EU trademark shall be declared to be revoked on application to the office or on the basis of a counterclaim in infringement proceeding. If within a continuous period of 5 years the trademark has not been put to genuine use in the Union in connection with the goods or services in respect of which it is registered and there are no proper reason for non-use. However, no person may claim that the proprietor's right in a new trademark should be revoked where during the interval between the expiry of the 5 years period and filing application or counterclaim, genuine use of the trademark has been started or resumed. The commencement or resumption of use within a period of 3 months preceding the filing of the application or counterclaim, which began at the earliest on expiry the continuous period of 5 years of non-use, shall, however, be disregarded where preparation for the commencement or resumption occur only after the proprietor becomes aware that the application or counterclaim may be filed. Let's see then the Chinese law. In China, the trademark law also addresses the issue of non-use of trademarks similar to the regulation in the US and the EU. The relevant legislation is the Trademark Law of the People's Republic of China, which includes provision regarding the consequences of non-use of a registered trademark. The Chinese trademark law does not explicitly require the use of the trademark at the time of application. However, once a trademark is registered, it is expected to be used in commerce. Justifiable reason for non-use of a trademark may include force majeure, government policy changes, or other circumstances beyond the control of the trademark owner. The CNIPA will consider these factors when deciding on the revocation of a trademark. The grace period, the 3-year non-use period effectively serves as a grace period following registration, during which the trademark owner should start using the trademark in commerce to avoid the risk of cancellation. The burden of proof in cancellation proceeding due to non-use, the burden of proof lies in the trademark owner to demonstrate that the mark has been used in commerce within the last 3 years or provide valid reason for non-use. Under Article 49, this is the article that provides that if a registered trademark has not been used for 3 consecutive years without proper reason, any entity or individual may request the China National Intellectual Property Administration, the CNIPA, to revoke the registered trademark. This is similar to the cancellation proceeding for non-use in the US and the EU. A trademark registrant that, without authorization, makes alternation which, with respect to the registered trademark, the name or address of the registrant or other registration items during the use of the registered trademark shall be ordered to make a correction within a time limit by the relevant local administrative department for industry and commerce. If it fails to make correction within the prescribed time limit, the trademark office shall cancel the registered trademark thereof. Where a registered trademark has become the generic name of the goods or which its use is approved, or registered trademark has not been put in use for 3 consecutive years without a justifiable reason, any entity or individual may apply to the trademark office for revocation of the registered trademark. And the trademark office shall make a decision within 9 months upon the receipt of the application. Where it is necessary under special circumstances, an extension of 3 months may be granted for making a decision upon approval by Administrative Department for Industry and Commerce of the State Council. Okay, the trademark registration application. Now I take just a sip of water. Sorry for that. Just for relax a minute, okay? Okay, let's finish up. If God willing, this one is the last half hour, and this is the last half hour of the IP exam, actually, studying part, actually. So, the application for registering a trademark. Application, part 1, application for registration for trademark are to be filed with the competent government authority, which in most countries is the same as the authority competent for processing patent application, USPTO, CNIPA, EUIPO, EPO. In general, countries provide for an application form for the use of which is mandatory in certain countries. The application form has to be completed with the name and address for the service in the country or to use an agent holding. Power of attorney to be signed, holding a power of attorney to be signed by an applicant. The Trademark Law Treaty contains in Article 3 a list of information which trademark officer of contracting parties may require for a trademark registration and expressly prohibit authentication or legalization, which are considered unnecessary and particularly burdensome. The applicant has also to list the goods for which the sign is to be registered. Trademark laws provide generally for a classification of goods for the purposes of registration. An important treaty for international trade is the NICE agreement concerning the international classification of goods and services for the purposes of the registration of marks, which establishes an international classification of goods and services for the purposes of registration of trademarks. Finally, one or more lots of fees have to be paid for the registration of a trademark. The examination phase. Countries generally accept an application for registration of a trademark only if the formal requirements are fulfilled. Most countries examine a trademark application as to substance in the interest of both the public and competitors. Trademark may be examined for absolute objective ground of refusal, that is whether they are sufficiently distinctive, not deceptive, etc. What we're talking about before, basically. The second part of examination, in general, there are three typical approaches. The British system, providing for examination by the office for absolute and relative grounds, and also for an opposition procedure. The French system, in which the office examines only for absolute grounds. The law provides for no opposition procedure, and it is left to the owner of the prior rights to bring a cancellation or infringement action against the registration or use of a more recent sign. In the German system, instead provides for an examination by the office for absolute grounds and also for an administrative opposition procedure in which the owner of the prior rights can oppose the infringing trademark application by means external to the system mentioned beforehand, and follows a modern trend which is reflected in the ESCTM, so in the European Trademark Regulation. The US, so let's see the US law approach. Without formal registration, user term in commerce can still accrue common law rights, granting the ability to prevent others from using similar marks in the same geographic area and continue using your marks despite later filings. There is a state versus federal registration. As we have seen before, there is a state and a federal trademark. State registration is suitable if the mark will be used only within one state. It offers more rights than common law, but is geographically limited. Federal registration instead is with the USPTO, is appropriate for marks used across state lines or on the internet. Federal registration provides several additional rights: nationwide exclusion of others from using similar marks, listing on the USPTO database for public notice, enforcement rights in federal courts, additional legal remedies for infringement, after 5 years the possibility of filing for incontestability. Initial steps in filing: applications are filed within the United States Patent and Trademark Office, the USPTO, online at uspto.gov. They need to decide between 1A, in use application if the goods services are currently available in the public, or a 1B, intent to use application if they are not yet available. Choosing classes for filing, review the list of international niche classes and determining which classes best represent the goods or services. Basic consideration are important, as fees are per class, not per application. If not currently using all goods services under the mark, consider separate application or a 1B application for future plans. Specific parameter of coverage: after deciding on application type, mark type, and classes, specify the parameters of your coverage and application. This includes detailed description of the goods or services associated with the marks. The description in your application is critical, as it sets the limits of the exclusion rights, and to keep the description broad enough to cover a wide range of users, but they must also be accurate and specific to your actual goods and services. You can use semicolons to list a multiple description and model, and the descriptions on a similar existing one. While broad descriptions are desirable, they must align with the specimens provided. Overclaiming can lead to issues if you can't show use for all listed goods or services. There is then TEAs Plus versus TEAs RF application. TEAs Plus application use preset description and are cheaper, are $2,025 per class, but offer less flexibility and have stricter compliance requirements, while the RF reduced fee application are slightly more expensive, $2,075 per class, but allow custom description and electronic communication. When filing for a logo or a trade dress, including a detailed description that allows someone to visualize the mark without seeing it, mention all colors and elements of the mark. Date of first use anywhere. The first date of the mark was used in any manner. Date of the first use in commerce, the date when the goods were first sold or services rendered under the mark. 1A versus 1B applicants. 1A use in commerce requires listing dates of first use and providing specimen. 1B intent to use for when the goods or services are not yet available to the public. Federal trademark application process. For 1A, there is the application filing. The USPTO reviews application. After meeting filing requirements, an examining attorney reviews the application to determine eligibility for registration. This one will take about 1 month for the review. USPTO approval publication and publication or office action. If approved, the trademark is published in the USPTO Trademark Official Gazette, TOMG, for opposition. If issues are found, an office action is issued. Respond within 3 months to avoid the abandonment. Submit after having submitted the response, then there is the question if the issue is resolved. The trademark is approved for publication. If unresolved, a final office action is then issued. Instead, for 1B, there is an application filing, the USPTO reviews, in which there is an assigned attorney, and the review takes normally 1 month. The USPTO approval and publication or the office action. If issues are identified, then action is issued, requiring response up to 3 months, response to the office action, and then the further approval or the final office action. So it's basically the same. The only difference is that the 1A, you are saying, I'm already using the trademark, and you have to give a date of commence, while the 1B is for a future trademark to be used. The final moment, there is an initial USPTO response, expected response from a USPTO in about 3 months. Total time from filing to registration ranges from 6-8 months to 18 months or 2 years, depending on the type of application. There is the office action that is common and often surmountable. An office action indicates deficits in the application. Example of easy office action include class designation disagreements, specimen issues, or required disclaimers. Other office actions involves potential confusion with other marks, inherent unregistrability, or lack of acquired distinctiveness. Respond within 6 months to address this issue. Final office action. If unresolved, the final office action is issued. Address this through a written legal argument or request for reconsideration. If still unresolved, appeal to Trademark Trial and Appeal Board (TTIB) may be necessary. After successful examination, the mark enters into a 30-day publication phase in the Official Gazette. Public can oppose the registration during this period. If opposed, you can respond or negotiate. You can take whatever. If unopposed, a 1A application leads to registration. For a 1B application, a notice of allowance is issued, requiring proof of use in commerce within 6 months or a request for an extension up to 5 times. Now, in the EU law, instead, the application for European trademark are filed at the EUIPO. The application requires detailed information about the trademark, including the mark itself, the goods and the services it will cover, and the owner's details. The application can be filed online via the EUIPO's website. After submission, the EUIPO examines the application for any absolute grounds for refusals. They also check if the application meets all formal requirements. If the EUIPO's examination is successful, the trademark application is published in the EU Trademark Bulletin. There is a 3-month opposition period during which third parties can oppose the registration if they believe it infringes their rights. If no opposition is filed or if opposition are resolved in favor of the applicant, the EUIPO registers the trademark. The registration is valid for 10 years from the date of application and can be renewed indefinitely for other 10 years period. In Chinese law, instead, you will need to file an application to the CNIPA. And the application must include a trademark, a list of goods or services it will cover, classified according to this classification, and the applicant's details. If the applicant is not domiciled or established in China, they must file the application through a legally established trademark agency in China. CNIPA conducts a formal examination to check if the applicant submits all the necessary requirements. If the application passes the formal examination, CNIPA conducts a substantive examination. This examination assesses whether the trademark complies with the relevant laws and regulations, including checks for distinctiveness and conflicts with prior right. Once the application passes the substantive examination, the trademark is published in the Official Trademark Gazette. There is a 3-month opposition period during which any third party can file an opposition to registration. If no opposition is filed or if the opposition is solved in favor of the applicant, CNIPA will issue a registration certificate. The trademark is then registered and protected in China. The registration is valid for 10 years from the date of registration. A trademark could be removed from the trademark registry on some grounds: removal for failure to renew, removal at the request of the registered owners, removal for failure to use, that we have seen before, cancellation on account of nullity, a trademark sign that should never have been registered, or removal of a mark that has lost its distinctiveness. The granted rights are the right to use and the right to exclude author to use trademarks. Let's face now unfair competition in the trademark world. So in the trademark world, the first one is the trademark infringement, hence using a trademark that is identical or confusing or similar to an existing trademark, leading to confusion among consumers about the source of goods or services. False advertising, making false or misleading statements in advertising that deceive consumers and affect purchasing decision. Trade dress infringement, copying the overall look and feel of a product's packaging or presentation, which could mislead consumer about the origin of the product. Trademark dilution, using a mark similar to famous trademark, even in the absence of competition or likelihood of confusion, that dilutes the distinctiveness or tarnishes the reputation of the famous mark. Passing off, this one is much more famous in the common law jurisdiction and in section 43A of the Lanham Act in the US, is selling goods or services under the pretense that they are associated with or originated from another source. Then there is the cyber squatting, that is registering, trafficking in, or using a domain name that is confusingly similar to a registered trademark with intent to profit from the goodwill of that trademark. In the United States, unfair competition in the realm of trademarks and trade practices is primarily governed by the Lanham Act, also known as the Trademark Act of 1946. The key provisions of the Lanham Act relating to the unfair competition are Section 32, that deals with infringement of registered trademarks, Section 33A. This is a crucial provision for unfair competition. It addresses false designation of origin, false description, and dilution. This section applies even if a trademark is not registered, offering a protection against any use of a mark or trade dress that is likely to cause confusion or deception. Section 43C covers trademark dilution, protecting famous marks from uses that would diminish their distinctiveness or harm their reputation. So, Section 32 says that any person who shall, without the consent of the registrant, use in commerce any reproduction, counterfeit, copy, or colorable imitation of the registered mark in the connection with the sale, offering for the sale, distribution, or advertising any goods or services or in connection with which such use is likely to cause confusion or to cause mistake or to deceive, or reproduce, counterfeit, copy, or colorably imitate a registered mark and apply such reproduction, counterfeit, copy, or colorable imitation to labels, signs, prints, packages, wrappers, receptacles, or in connection with the sale, offering, of the sale, distribution, or advertising of goods or services, or in connection with which such use is likely to cause confusion or to cause mistake or to deceive. Shall be liable in a civil action by the registrant for the remedies and after provided. Under subsection B hereof, the registrant shall not be entitled to recover profits or damages unless the acts have been committed with knowledge that such imitation is intended to be used to cause confusion or to cause mistake or to deceive. Okay, number 2 of the section 32. Notwithstanding any other provision of this chapter, the remedy is given to the owner of the right infringed under this chapter or to person bringing an action under section 1125A or D of this title shall be limited as follows. Where an infringer or violator is engaged solely in the business of printing the mark or violating matter of others and establishes that he or she was innocent infringer or innocent violator, the owner of the right infringed or person bringing the action under section 1125A of this title shall be entitled as against such infringer or violator only to an injunction against fruit or printing. Where the infringement or violation complained if it is contained in or is part of paid advertising matter in a newspaper, magazine, or other similar periodical or in an electronic communication as defined in section 251 of Title 18, the remedies of the owner of the right infringed or person bringing the under section 1125A of this title as against publisher or distributor of such newspaper, magazine, or other similar periodical or electronic communication shall be limited to an injunction against the presentation of such advertising matter in future issues of such newspaper, magazine, or other similar periodicals or in the future transmission of such electronic communication. The limitation of this subparagraph shall apply only to innocent infringers and innocent violators. In section 43A is a crucial provision for unfair competition as a civil action. Any person who, in connection with any goods or services or any container for goods used in commerce, any word, terms, name, symbol, or device, or any combination thereof, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact which is likely to cause confusion or to cause mistake or to deceive as to the affiliation, connection, or association of such person with another person, or as to the origin, sponsorship, or approval for this good or services or commercial activities by another person, or in commercial advertising or promotion misrepresents the nature, characteristics, qualities, or geographic origin of his or another person, goods, services, or commercial activities, shall be liable in a civil action by any person who believes that he or she is likely to be damaged by such act. As used in this subsection, the term any person includes any state, instrumentality of a state, or employee of a state, or instrumentality of a state acting in his or her official capacity. Any state and any such instrumentality, officer or employee shall be subject to the provision of this chapter in the same manner and to the same extent as any non-governmental entity. In the civil action for the trade dress infringement under this chapter for trade dress not registered under the principal register, the person who assert trade dress protection has the burden of proving that the matter sought to be protected is not functional. Number C is the dilution by blurring or dilution by tarnishment. Subject to the principle of equity, the owner of a famous mark that is distinctive, inherited, or through acquired the distinctiveness shall be entitled to an injunction against another person who, at any time after the owner's mark has become famous, commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous market, regardless of the present or absence of actual or likely confusion or competition and or of actual injury. Dilution by blurring is association arising from similarity between a mark or trade name and a famous mark that impairs the distinctiveness of the famous mark, in determining whether a mark or trade name is likely to cause dilution by blurring. For purpose of paragraph 1, dilution by tarnishment is association arising from the similarity between a mark or trade name and a famous mark that harms the reputation of the famous mark. In the European Union, unfair competition about trademark practices is addressed through the combination of EU-wide directives and regulations as well as individual member states' law. The primary EU legislation pertaining to trademarks in the European Union, as we have seen many times, is the Trademark Regulation and the Trademark Directive. European Union's Trademark Regulation governs the registration and protection of European trademarks, which offer uniform protection across all EU member states, addresses issues such as trademark infringement, which can include the unauthorized use of a trademark that is identical or similar to a registered trademark, especially where such use causes a likelihood of confusion. Trademark infringement, using a sign that is identical or similar to a registered trademark for identical or similar goods or services linked to a likelihood of confusion. The UTMR and the national laws provide remedies for infringement. Comparative advertising, our directive on misleading and comparative advertising set out conditions under which comparative advertising is permitted. Comparative advertising must not be misleading and must not create confusion between the advertiser and the competitor. Passing off. While the concept of passing off is more prevalent in common law, the countries like the UK, many EU countries have similar doctrines under the unfair competition laws. It involves misrepresenting one good or services as those of another, causing damage to the latter's goodwill. Cybersquad and domain name dispute, addressed under both EU regulation and the Uniform Domain Dispute Resolution Policy, UDRB, for .eu domains, involves registering domain names similar to trademarks with bad faith intent. In China, the trademark law of the People's Republic of China governs the registration, use, and protection of the trademarks in China, provides the legal basis for action against trademark infringement and counterfeit trademarks. Anti-unfair competition laws of the People's Republic of China address various forms of unfair competition, including deceptive and misleading practices and infringement of trade secret and commercial slander. Includes provisions against acts of confusion that can mislead consumers about the origin of products or services closely related to trademark protection. Passing off, the anti-unfair competition law prohibits acts that can cause confusion with another's enterprise, such as unauthorized use of a company name, packaging, or decoration of another famous products. Enforcement and remedies. Remedies for infringement include cessation of infringement, compensation for damages, and elimination of ill effects. Administrative judicial routes are available for enforcement. The China National Intellectual Property Administration, the CNIPA, handles administrative action against trademark infringement. Domain name disputes, managed under the China Internet Network Information Center, CNNIC. Domain name dispute resolution policy allies with global practices such as the ICANN policies for resolving domain name disputes involving trademark issues. And we arrive to the end. I hope this one was extensive enough. I hope you like it, and much more of that, I hope it was useful. So thanks a lot. I will probably upload other videos related to other exams, and yeah, bye bye, ciao ciao.